My name is Karen Lee Pollock. I'm an immigration attorney at the law firm of Bell, Nunnally and Martin. Today I'm going to talk about obtaining a green card through employment in the EB-2 or EB-3 category. That is employment-based 2 or employment-based 3 category. The employment-based 2 category is for somebody who has a master's degree from a US accredited university or a bachelor's degree and 5 years of experience. And an EB-3 category visa is for a professional or a skilled worker. Which category you decide to go with depends on your education and your skills. And it's very important to decide because the wait times for EB-3 may be significantly longer than an EB-2. You also need to decide whether the employee is located in the United States or outside the United States, because part of the procedure will differ if they are in the United States. The first stage, regardless of whether the employee is located within the United States or outside the United States, is to file a labor certification application. It's often called PERM, which stands for Program Review Electronic Management, and that is filed with the Department of Labor. Prior to filing your PERM application, you would have to advertise for the job in a newspaper of local circulation on 2 Sundays. If the job is for a professional position, you will also have to advertise in 3 alternative recruitment forms as well for the job. So as, for example, on campus, online, on your own intranet site, and this will really depend on the employer. Once you've advertised in these additional forms of recruitment if needed, you also need to advertise with the state workforce agency where the employee will be working. You will have to wait a certain period of time and document all people who applied for the job. This is useful if you put that on a spreadsheet with their contact information, how they heard about the job, and lawful reasons for not hiring them. You do not need to interview everybody who applies for the job, just those people who on the face of their resume qualify. And then you will have to document efforts to try and reach them, and if you do interview them, you will have to document, as I said, the lawful reason for not hiring them. Once you have done this recruitment process, you will then file the PERM application with the Department of Labor. Assuming that nothing goes wrong and there's no audits or requests for evidence, you will usually get an answer from the Department of Labor in 90 days. You will receive an approved labor certification, and you and your employee will have to sign it. You are attesting that there are no US qualified workers who will take the job and that you are not displacing any US workers. Once you have this approved labor certification, you can file a petition for alien worker or Form I-140. In that petition, you provide information about the employee and information about the business hiring the employee. You will need to provide financial information, passport information on your employee, their qualifications, letters of reference if required, their degrees, and any documents in a foreign language must be translated. There is a mechanism whereby you can get approval of this phase of the green card application in 2 weeks by paying additional $1,225 to the immigration authorities. This is called premium processing. And in some cases, it's well worth paying that money. However, if there are long wait times to wait for a visa, you may not want to spend additional funds on premium processing. In addition to paying your general filing fee, your premium processing fee, and providing the supporting documents, you would also provide other information on your company to USCIS. Once the USCIS makes a decision and hopefully approves the application, you will then be able to go on to the next phase of the green card application, which is either adjustment of status if the applicant or employee is in the United States and there is a visa available for them, or you will be able to file with the Kentucky Consular Center and the U.S. Consulate in the home country if there is a visa available for the employee. In some aspects, there is long wait times in EB-3, so you cannot go immediately apply for a visa in the EB-3 category. You can get the I-140 approved, but will have to wait in line until a visa becomes available. Also, if you are from certain countries, the wait time can be longer than others. Philippines and Mexico can be longer than, say, your employees from Denmark or England. So those are factors that you need to take in account in determining how to sponsor your employee and when to sponsor them and in what category. If you have questions about an employment-based 2 or employment-based 3 visa, please feel free to call me. I look forward to talking to you.